Hello, this is Judge Dale Wells, and welcome to part 2 of our study of California protective orders. In our first hour, we talked about the most commonly known protective orders, the emergency protective orders that are able to be obtained when there's some kind of an urgent situation that requires some kind of an immediate order from a magistrate. And we talked about domestic violence restraining orders that are generally against people that you have some kind of a defined relationship with. And we talked about civil harassment orders that don't require a defined relationship. Well, in our second session, we're going to talk about lesser-known orders. Orders pertaining to workplace violence, school violence, gun violence, juvenile dependency and delinquency orders, elder abuse, criminal protective orders, and then we're going to talk about how they all fit together and what are the priorities for enforcement. So we'll begin by talking about workplace violence. The workplace violence protective orders are defined and the laws for them are found at Code of Civil Procedure, Section 527.8. In order to get a workplace violence order, there has to be a reasonable proof of unlawful violence or a credible threat of violence by the respondent, and that great or irreparable harm would result to the employee. And in order to get a temporary restraining order, you have to have reasonable proof of that. In order to get an order after hearing, that's that OAH we talked about before, there has to be clear and convincing evidence. So the standards of law here, the standards of proof are the same here as for a civil harassment pertaining restraining order. And that is a reasonable proof for a temporary restraining order, clear and convincing evidence for an order after hearing. Well, what brings about a workplace violence restraining order? Well, there has to be an allegation that the employee has suffered an unlawful act of violence or a credible threat of violence from any person that can reasonably be construed to be carried out or to have been carried out at the workplace. Well, what is a credible threat of violence? The law defines that in CCP 527.8b2 as a knowing and willful statement or course of conduct that would place a reasonable person in fear for himself or herself or for their immediate family, and that serves no legitimate purpose. And a course of conduct is also defined in the statute. It's a pattern of conduct composed of series of acts over time, however short, evidencing a continuity of purpose, including following or stalking the employee to or from the workplace, entering the workplace, following the employee during work hours, making telephone calls to the employee, sending correspondence by any means, including the use of public, private, or inter-office mails, or fax or computer email. Well, who can petition? This is the kind of a restraining order that's filed by the employer on behalf of the employee. And the employer-employee relationship is defined in Labor Code Section 350. Who can be protected? Well, the employee, and in the discretion of the court, and for good cause, the family or household members of the employee and other people employed at the workplace or at other workplaces. What kind of orders are available? Well, there's the usual personal conduct, which is do not harass, attack, strike, threaten, assault, all of those orders that I call the Be Nice orders. There are no contact orders that can be made, and stay-away orders. But the court can also fashion other restraints on behavior that it determines that are necessary to effectuate the orders that it makes. But as with all restraining orders, once a person is subject to a workplace violence restraining order, they have to relinquish firearms and ammunition. They have to turn them into law enforcement, sell them to a licensed gun dealer, or store them with a licensed gun dealer. As is the case with temporary restraining orders we've looked at before, the temporary restraining order is a very short-term order. It lasts 21 days, 25 days if the court finds good cause. Again, those are calendar days, not court days. An order after hearing can last not more than 3 years. And if someone seeks a renewal of that order, it can be renewed for not more than 3 years upon the request of the party without a showing of further violence or a threat or since the issuance of the original order, as long as it's brought within 3 months of the expiration of the original order after hearing. Due process is pretty much like the civil harassment restraining order. It requires personal service on the respondent at least 5 days before the hearing, and the respondent may file a response that explains or justifies or denies the alleged harassment. Again, if the respondent hasn't had sufficient time to answer, they're entitled to one continuance for a reasonable period to respond to the petition, and either party may request, either in writing or orally, or it can be granted on the court's own motion, a continuance for good cause. If someone seeks to modify or terminate a workplace violence order, it requires personal service on the protected party at least 16 days in advance of the hearing to terminate or modify the restraining order prior to the date that expires. Now, unfortunately, school violence is one that we may be seeing more and more of in the weeks and years to come, and it's defined in Code of Civil Procedure 527.85. The burden of proof for a school violence restraining order, for a temporary restraining order, once again, is reasonable proof that the student has suffered credible threat of violence made off campus and that great or irreparable harm would result to the student if the order were not granted. And an injunction, in this case, is what you would call the order after hearing, is based upon clear and convincing evidence of a credible threat of violence off the school campus or facility. Well, who petitions for this? In this case, it's the chief administrative officer or the designee of a private post-secondary educational institution that brings the request for a school violence restraining order. And the people that are protected? Well, it's the student, who may be an adult currently enrolled in or applying for admission to a post-secondary institution, if that is the case, but a student in any case. And it could be the student's family or household members upon a showing of good cause, and other students at the campus or facility who are similarly situated, again upon a showing of good cause. Now, in order to seek this order, the school has to have the written consent of the student. And with the written consent of the student, the school official may seek protection under this law if the student has suffered a credible threat of violence from any individual and there's a credible threat of violence while made off-campus facility can reasonably construed to be carried out or have been carried out at a school or campus facility, and the respondent's conduct is not allowable as legitimate labor dispute permitted by CCP 527.3, and the respondent is not engaged in any constitutionally protected activity. So, definitions are important, once again. A credible threat of violence is a knowing and willful statement or course of conduct that would place a reasonable person in fear for his or her safety or the safety of his or her immediate family, and that serves no legitimate purpose. And a course of conduct is a pattern of conduct composed of a series of acts over a period of time, however short, evidencing a continuity of purpose, including any of the following or stalking the student to or from school, entering the school campus or facility, following the student during school hours, making telephone calls to the student, sending correspondence to the student by any means, including the use of public or private mails, interoffice mail, fax, or email. And what kind of orders are available? Well, the temporary restraining order will include personal conduct orders. Those are the Be Nice orders. It can include stay-away orders. Stay 100 yards away from this person or from the school facility. And it can include other restraints that are necessary to effectuate the court's orders. As is always the case, the issuance of a school violence order, even a temporary restraining order, requires the restrained party to sell firearms to a licensed gun dealer, store them with a licensed gun dealer, or turn them into law enforcement, and they're not allowed to own, possess any firearms or ammunition during the period of time that this order is in effect. The permanent order, what we've been calling the order after hearing, what we're now calling an injunction, can include everything that was ordered in the temporary restraining orders. The temporary restraining order, once again, like all others we've seen before, lasts 21 calendar days or 25 days with good cause finding by the court. The injunction can last up to 3 years, and if the injunction is silent about how long it lasts, it will last 3 years. And if it's renewed, it can be renewed for not more than 3 years upon request of the party without a showing of further violence or threats, and that can be brought at any time within 3 months before the expiration of the order. Well, due process, in this case, an ex parte order may be issued pursuant to CCP 527. That's that temporary restraining order. The temporary restraining order has to be served at least 5 days before the hearing, and the respondent is entitled to one continuance for a reasonable time, but either party can get a continuance for good cause. And if the restraining order is sought to be modified, the person seeking the modification has to serve the protected party at least 16 days in advance of the hearing to terminate or modify the restraining order prior to the expiration date, and the protected party may waive notice. Well, unfortunately, along with school violence, we have a restraining order for gun violence. The statutes are found in the Penal Code, but the process to obtain a gun violence restraining order is actually a civil proceeding. But the Penal Code section is Penal Code Section 18100 et sec. What's the burden of proof? Well, in order to get an emergency protective order, which is called a temporary emergency gun violence restraining order, the court has to have reasonable cause to believe, one, that there's an immediate and present danger that the restrained party will hurt him or herself or someone else with a firearm, and two, less restrictive measures have been ineffective or are inadequate or inappropriate. The TRO, the ex parte gun violence restraining order, is issued upon a substantial likelihood that the restrained party poses a significant danger of hurting himself or herself or others with a firearm, and that a temporary restraining order is necessary because less restrictive alternatives are ineffective or inadequate or inappropriate. The order after hearing is based upon clear and convincing evidence that the restrained party poses a significant danger in the near future of hurting himself or others with a firearm, and the TRO is necessary because less restrictive alternatives are ineffective or are inadequate or inappropriate. So who can bring the request for this? Well, the emergency protective order can be only requested by law enforcement. And it's a written or oral petition that's given to the court on which the court has to make its findings to grant or deny the emergency protective order, the temporary emergency gun violence restraining order. The TRO, ex parte gun violence restraining order, well, that request can be brought by law enforcement or an immediate family member, and it also is brought by a written petition. The order after hearing, it can be brought by a law enforcement or an immediate family member, and it's also by a written petition. Now, the emergency protective order lasts for 21 calendar days, and there is no procedure allowed to extend or make that order permanent. So someone has to come into court in that 21 calendar days to get the temporary restraining order. That order can last 21 calendar days. The hearing has to be held within 21 days. So on the one hand, for an emergency protective order, law enforcement comes and convinces the judge there's need for an emergency action to remove guns from this person. But if some family member believes that there is such a need, they can bring that request seeking a temporary restraining order. The order after hearing can result in an order that requires the person to give up firearms. The factors the court has to consider are, one, a recent threat of violence toward the person or others, and whether there's been a violation of an emergency protective order issued under the Family Code or a violation of a civil harassment or elder abuse or domestic violence order. A conviction under Penal Code Section 29805, which prohibits post-conviction possession of a firearm, is something the court would consider. A pattern of violent acts or threats in the last year to harm oneself or others. And other evidence of an increased risk for violence, for example, using, brandishing a firearm, a prior felony arrest, restraining order violations, drug offenses, things like that. What kind of orders are available? Well, an order prohibiting and enjoining a person from having custody or control of, or owning, or purchasing, or possessing, or receiving any firearms or ammunition. But notice this doesn't allow for any stay-away provisions. It doesn't allow for personal conduct orders. It doesn't allow for move-out orders. This simply has to do with possession and ownership of firearms. And there's an order for the person to surrender their firearms and ammunition immediately to the requesting officer or within 24 hours of service and file a proof of having done so within 48 hours. The statute does not give any information about what kind of notice is due for the hearing. For termination, the restrained party can request an early expiration of the order if that person can show that there's no longer clear and convincing evidence. The court is required to terminate that order. Otherwise, it can be renewed for not more than 1 year upon the request of law enforcement or a family member at any time within 3 months of expiration. Now, juvenile dependency and delinquency is a very complex kind of proceeding. And so I'm going to look at them together and show how they fit together and how they differ. For a temporary restraining order, if it's related to domestic violence, whether it's dependency or delinquency court, what's required is a reasonable proof of a past act or acts of abuse. If it's not related to domestic violence, there needs to be reasonable proof of some kind of harassment or unlawful violence or a credible threat of violence, and that great or irreparable harm would result to the petitioner if the order was not allowed. In other words, you're looking at, if it's a domestic violence-based situation, the same kind of things the court's looking at for a DV restraining order for an adult. If it's a civil harassment type of situation, or workplace violence or school violence or one of those things, you're looking for the same kind of evidence that you'd be looking at for a civil harassment restraining order. The order after hearing, if it's related to domestic violence, is looking for a preponderance of evidence, and the court has to rule based on a preponderance of evidence, which is the more likely than not. But if it's not related to domestic violence, the standard of proof is clear and convincing evidence. So the critical difference between these two is going to be whether that relationship exists that makes it a domestic violence case or not. When can a restraining order be filed? Well, in dependency court, after a 300 petition has been filed, it can be filed at any time until the petition is dismissed or dependency is terminated. In delinquency, it can be filed after a 601 or 602 petition has been filed and until the petition is dismissed or wardship has been terminated. How can it be filed? Well, it can be filed orally at any scheduled hearing, by written application, which must be submitted on a particular form, JV 245. It can be brought on the court's own motion. And who can petition? Well, the parent, the child, the guardian, the social worker, the probation officer, the present caregiver of a child, a court-appointed special advocate, representative of an Indian tribe, or some other person with an interest or a relationship to the child. And who can be protected? Well, in dependency, the dependent or child subject to a 300 petition, because the juvenile court has exclusive jurisdiction for restraining orders regarding dependent children. So in dependency, a dependent or child subject to the petition can be protected. Other children in the household can be protected for the same reason. Juvenile court has exclusive jurisdiction for restraining orders regarding children in the home of dependent children. a parent or legal guardian or current caretaker of a child, regardless of whether the child resides with them, a current or former social worker, a current or former court-appointed special advocate. And in delinquency, who can be protected? Well, a ward can be protected, or a child subject to that 601-602 petition, other children in the household of the ward, the parent, legal guardian, or current caretaker of the child, regardless of whether the child resides with them, a current or former probation officer, a current or former court-appointed special advocate, and if the restrained party is a ward or subject to a 601-602 petition, any person the court finds to be at risk from the conduct of that child, and any person with whom association with the child would be detrimental to the child. Who can be restrained? In dependency, any person can be restrained. In delinquency, any person can be restrained, but the ward or child subject to the 601-602 petition can be restrained as well. What about the hearings and burden of proof? In dependency and delinquency, the application can be heard simultaneously with any scheduled hearing, and proof at the hearing may be made by application and attachments or additional declarations or documentary evidence, contents of the juvenile court file, testimony, or any combination thereof. And the orders have to be prepared on the juvenile forms JV-250 and JV-255. What kind of orders can be made? Well, in dependency and delinquency, the personal conduct orders. Do not molest, attack, strike, stalk, threaten, sexually assault, batter, harass, telephone, including but not limited to making annoying calls as described in Penal Code 635M. Destroy personal property, contact either directly or indirectly by mail or otherwise, or come within a specific distance or disturb the peace of. And orders can be made to exclude any person from dwelling of the person who has the care, custody, and control of the child. Again, because the juvenile court has exclusive jurisdiction for residence exclusion orders regarding dependents. Other orders that can be made: take no action to get the address or location of the protected person or family members or caregivers and guardians. Do not use, own, possess any guns, firearms, ammunition, and relinquish those in or subject to immediate possession or control within 72 hours of receiving the order. Good cause. In delinquency only, orders that can be made to enjoin a delinquent child or child subject to a 601-602 petition not to contact, threaten, stalk, or disturb the peace of any person whom the court finds to be at risk from conduct of the child or with whom the association would be detrimental to the child. And for delinquency only, orders that can be made to enjoin the delinquent child or child subject to the 601-602 petition to not contact, threaten, stalk, or disturb the peace of any person whom the court finds to be at risk from the conduct of the child or with whom association would be detrimental to the child. And again, the Juvenile Justice Court may issue a wide variety of restraining orders, including no contact and stay away orders, despite the legislature's failure to repeat the list of enjoinable conduct in 602 proceedings. In order to get a residence exclusion order, the court may exclude the person from the dwelling of a person who has the care, custody, control of a child, regardless of which party holds legal or equitable title or is lessee, only on a showing that the party who will stay in the dwelling has a right under color of law to the possession of the premises, and the party to be excluded has assaulted or threatened to assault the other party or any person under the care, custody, and control of the other party or any minor child of the party or of the other party, and that physical or emotional harm would otherwise result to the other party, to any person under the care, custody, and control of the other party, or any minor child of the party or of the other party. So how long do these last? Well, the ex parte TRO, again, lasts 21 to 25 days if good cause is found by the court. The order after hearing can last up to 3 years, and it does not end automatically at the termination of the juvenile case. In order to terminate or renew, It may be terminated by the court before the expiration date or extended by mutual consent of all parties to restraining orders, or extended by further order of the court on motion by any party to the restraining order. A violation, willful and knowing violation, is a misdemeanor punishable under Penal Code 273.65. Due process. The TRO can be granted ex parte. Notice of the hearing has to be at least 5 days of the TRO being granted or 2 days before the hearing. A continuance can be given to the respondent at least once, but either party can get a continuance on a showing of good cause. Now, something that's probably not going to be particularly helpful to you as minors counsel, but it's another available restraining order, is the elder abuse restraining orders. The purpose is to prevent the recurrence of abuse. And the burden of proof is reasonable proof of a past act or acts of abuse. There is no need to show that the acts will continue or repeat, and the burden of proof is preponderance of evidence. Elder abuse includes physical abuse, neglect, financial abuse, abandonment, isolation, abduction, or treatment with resulting physical harm, pain, or mental suffering. But it also includes depriving the care, custodian of goods or services necessary to avoid physical harm or mental suffering. Who's protected? Well, an elder adult, who's defined as a person residing in California 65 years of age or older. Or a dependent adult, which is an adult between ages of 18 and 64 with physical or mental limitations that restrict their ability to carry out normal activities, or to protect the rights includes those who have physical developmental disabilities or whose physical mental abilities have diminished because of age, or who is between those ages and is admitted as an inpatient to a 24-hour health facility as defined by Health and Safety Code statutes that are given there. Who's protected? The elder person, who is again a person residing in California 65 years of age or older. A dependent adult, which is that person between the ages of 18 and 64 with those physical disabilities, and the family or household members or conservator in discretion of the court for good cause. Who can petition this? Well, the elder or dependent adult can do it themselves. The conservator can do it. The trustee of the person can do it. The attorney in fact, acting within the authority of that attorney in fact designation, a guardian ad litem can do it, or any other person authorized by law. And according to Welfare and Institutions Code, County Adult Protective Services can also ask for these orders. What kind of orders can be given? Well, a temporary restraining order would include personal conduct orders, which are those be nice orders. No contact and stay away orders can be granted. Orders pertaining to the care and protection of pets can be granted. Residence exclusion orders can be granted. And other restraints to effectuate the court's orders can be granted. There is a provision that if an elder abuse order is granted, then the person who is subject to it cannot own or possess and must relinquish their firearms, but if the only abuse that's alleged is financial abuse, unaccompanied by force, threat, or harassment or intimidation, or some other form of abuse, the firearm order is not given. This is the only restraining order where the firearm order is not automatic in all cases. And an order prohibiting the restrained person from getting the address of the protected party. After hearing, all the ex parte orders can be granted. In addition, the residence exclusion order, if the court finds that the physical or emotional harm would result to the petitioner or the family or the household member if that order was not granted. An attachment may be issued for damages if the order is based upon financial abuse. And of course, the prevailing party can get attorney's fees and costs. The residence exclusion on the temporary restraining order, in order for an ex parte residence exclusion, there has to be a showing of that the party who will stay in the residence has the right under color of law to the possession of the premises, and that the party to be excluded has assaulted or threatened to assault the petitioner, the family or household member, or the conservator, and that physical or emotional harm would otherwise result to the petitioner or other named family member or household member or conservator. The residence exclusion on an order after hearing. After notice and hearing, the court may issue a residence exclusion order if physical or emotional harm would otherwise result to the petitioner, other named family or household member, or conservator. But no residence exclusion order can be granted if legal or equitable title or lease is in the sole name of the party to be excluded or in the name of the party to be excluded and another party besides the petitioner. Well, how long do these orders last? Well, the temporary restraining order, as you would expect, lasts 21 days to 25 days if good cause is found. And if the matter is continued, the temporary restraining order remains in effect. The order after hearing can last for not more than 5 years, and if the order is silent, it will last for 3 years. The person who prevails can get attorney's fees and costs, where there's clear and convincing evidence that the defendant is liable for physical abuse or neglect, and that the defendant has been guilty of recklessness, oppression, fraud, or malice. The court shall award reasonable attorney's fees and costs, including fees for the services of the conservator devoted to litigation of the claim brought under this order. For due process, ex parte orders can be granted. The TRO requires service at least 5 days before the hearing, and the response can be filed either explaining or denying the alleged abuse. And the person who needs to respond is entitled to one continuance for a reasonable period of time to respond, but of course either party can get a continuance for good cause or even on the court's own motion. Well, the last protective orders we're going to talk about are the ones that probably we don't think about so much in the civil background, but we do think about them in a criminal setting, and that is the criminal protective orders, Penal Code Section 136.2. The purpose of criminal protective orders is to protect a victim or witness in a criminal case, and the burden of proof is a good cause belief that harm, intimidation, or dissuasion of a victim or witness has occurred or is likely to occur. What kind of orders are available? Well, there are personal conduct restraints, stay-away orders, and orders that the defendant not violate Penal Code 136.1, which is dissuading a witness. And any other person other than defendant must not violate Penal Code 136.1 either. Witness protection orders, orders that prohibit the person from taking action to locate the protected party. And again, firearms orders. The person subject to this cannot own, possess, purchase, or receive firearms, and cannot own, possess, or have in custody or control ammunition. This order lasts until the defendant is no longer subject to the court's jurisdiction. And then a new order will take place that's a post-conviction order. So what will typically happen is there will be an initial order that's made when a person is arraigned on the initial complaint. And that order will remain until there is either conviction or a plea. And at the time of the plea and sentencing, or the sentencing after conviction, that original order is dissolved and a new order is put in place if the court if the person was convicted or pled to the crime. So the post-conviction order, if a defendant is convicted under Penal Code 273.5a, or of a crime of domestic violence as defined in Penal Code 13700, the sentencing court must consider issuing a no-contact restraining order which may be valid for up to 10 years as determined by the court. This protective order may be issued by the court whether the defendant is sentenced to state prison, county jail, or if imposition of sentence is suspended and the defendant is placed on probation. So those are the different kinds of restraining orders that we have available to protect people in California. But how do they fit together? And if you have multiple restraining orders, how does law enforcement know which one to enforce and in what order? Well, here's the priorities for enforcement. Emergency protective orders, if they're more restrictive and they relate to the same parties, have the highest priority for enforcement. Any no-contact provision in any restraining order, whether it's criminal or civil, has a higher priority than any other order. A criminal protective order comes right after that. The most recent civil order comes right after that. And that's the priorities for enforcement. The emergency protective order, any no-contact provision in any restraining order, a criminal protective order, and the most recent civil order. Well, those are the 9 kinds of protective orders available in California. In our first hour, we talked about emergency protective orders, domestic violence restraining orders, and civil harassment restraining orders. In our second hour, we talked about workplace violence, school violence, gun violence, juvenile dependency and delinquency, elder abuse, criminal protective orders, and priorities of enforcement. I hope this review has helped make you aware of tools that you may need in representing minors as minors counsel. And thank you for your participation and for your continued service as minors counsel.